I welcome all the distinguished professors. So I'm Professor Balraj Chauhan, President, Indian Society of Criminology. And I welcome President of the International Society of Criminology and other friends from abroad. Where is Srikar?
Hello, sir. Yes, sir, I'm here.
Please.
Good evening. Good evening, sir.
Very good evening.
Boss, I have joined. I'm already there. You see me?
Hi, Professor Madhavan.
Good morning, sir. How are you, sir?
I am fine, thank you.
Uh,
Umar is also okay.
oh, hello, Umar.
So,
hello, Professor.
I am excited to hear Amilo, Professor Amilo, because
International Society, yes.
Hello, good afternoon, everyone. On behalf of the Department of Criminology and Police Studies, Sardar Patel University of Police Security and Criminal Justice, I, Jayesh Kumar, PhD scholar, welcome you all to the International E-Symposium on Supranational Criminology, dealing with international trends. Without further ado, I would like to welcome Dr. Srikar Lama, Organizing Secretary of this International E-Symposium and Assistant Professor, Department of Criminology and Police Studies, to deliver the welcome address.
Good afternoon. On behalf of the Department of Criminology and Police Studies, Sardar Patel University of Police, Security and Criminal Justice, Jodhpur, I heartily welcome you all to the International E-Symposium on Supranational Criminology, dealing with the international crimes. As the saying goes in Rajasthan, Padharo Maro Desh, which means welcome to our land. Although in this COVID times, unfortunately, we are not able to welcome our guests to Rajasthan and to our university, but we welcome you all in this virtual platform. I welcome Professor Dr. Emilio Viano, the Honorable President of our partner, International Society of Criminology, Professor Balraj Chauhan, the Honorable President of our partner, Indian Society of Criminology, and the Vice Chancellor of Dharmashastra National Law University, Jodhpur, Professor Madhava Somasundaram, Chairman of Indian Society of Criminology and Head of Department of Criminology and Criminal Justice, Manumanyam Sundaranara University, Tirunelveli, and Dr. Syed Umar Atab, Secretary of Indian Society of Criminology. I also welcome the patron of this e-symposium, the Registrar of a University, Mrs. Vandana Singh in absentia, who was unfortunately not able to join us as she had to travel due to some important work and will be joining us in the valedictory session tomorrow. I would also like to welcome our keynote speakers, Dr. Mohammed Matar, Clinical Professor of Law and Head of the Legal Skills Department, Qatar University College of Law, Professor Greg Barak, Professor of Criminology and Criminal Justice, Department of Sociology, Anthropology and Criminology, Eastern Michigan University, Professor George Richards, Department of Criminal Justice, Anthropology and Forensic Studies, Edinburgh University of Pennsylvania, Professor Dr. Jacob Barkuzwan, President of Criminological Society of Africa, CRIMSA, Head of Department of Criminology and Criminal Justice, University of Limpopo, Dr. Michael O'Connell, Secretary General, World Society of Victimology and Vice President of NGO Alliance on Crime Prevention and Criminal Justice, UNODC, Professor Gamil Popel, criminal lawyer and professor at the Federal University of Bahia, and Dr. George A. Restrepo, economist from Pontificia in Universidad Xavier and University of the Royal Holloway, University of London. We also welcome all the chairpersons of the sessions, Professor R.N. Mangoli, Vice Chairman, Indian Society of Criminology and Director and Chairman, Department of Criminology and Criminal Justice, Rani Chennamma, University, Belgavi, Professor G.S. Vajpayee, President, Indian Society of Victimology and Registrar, National Law University, Delhi University, and Professor Arvind Tiwari, former President of Indian Society of Criminology and Dean School of Law, Rights and Constitutional Governance, Sardar Institute of Social Sciences, Mumbai. I welcome all the respected professors and academicians from abroad in India, Deputy Director of Northeastern Police Academy, Ms. Gebulti Channamam, all practitioners, research scholars, and students. In today's world of globalization, the topic of this e-symposium is very pertinent. The world has already seen that many events in any part of the world ultimately affect the entire world for good or for bad. Unfortunately, the corona pandemic is the latest example of this phenomenon. The world of crime is also not untouched by this globalization effect of this phenomena. The world of crime Sorry. The world of crime is also not untouched by this globalization effect, as many international crimes like terrorism, where organizations like ISIS has spread the tentacles around the world. Crimes like environmental crimes have no boundaries and affect all of us and will even affect our future generations. As the topic of the e-symposium affects every region of this world, we have invited speakers from all 6 continents of this world. This symposium has these objectives: to introduce various aspects of supranational criminology to academicians and students, to bring awareness about the kind of research being conducted in supranational criminology, to bring awareness about practices or policies of the government and law enforcement agencies being used to deal with international crimes in various regions of the world, and to discuss about the role of criminologists in dealing with international crimes. We hope that through the various sessions which we have planned during these 2 days, we will be able to meet these objectives and come up with some ways of dealing with international crimes. Once again, I welcome you all and hope this e-symposium will be a fruitful one. Thank you.
Thank you so much, Vikas sir. Now I kindly request Professor Dr. Emilio Viano, the Honorable President of our partner International Society of Criminology, who is the professor at American University, Washington, D.C., and affiliated professor at George Mason University, to say a few words.
Professor, you will have to unmute your mic. Professor, you will have to unmute. Professor Viano, you will have to unmute your mic.
Yeah, I'll just give him hello. I'll just give him a call.
Professor Viano,
So I'll give him a call. I guess he is not.
please unmute. Your mic is muted. You will have to unmute, sir.
Sorry for technical errors. Thank you so much, sir. Now I kindly request Professor Balraj Chauhan, the Honorable President of our partner Indian Society of Criminology and the Vice Chancellor of Dharmasastra National Law University, Jabalpur, to address the gathering.
Thank you, Jayesh. At the outset, I would like to welcome all the friends from Indian Society of Criminology, particularly its president, Dr. Professor Emilio Viano. He's a professor of American University, Washington, D.C. I was excited to hear him, but I don't know, because of this technological glitch, it will be possible after some time. I welcome Mr. Mohammad Machar, my friend Professor Madhavan Somasundaram, Chairman of the Indian Society of Criminology, Dr. Mangoli, and especially all the friends who are attending this particular International E-Symposium on a very important topic or issue, supranational criminology, dealing with the international crimes. Two words are very important: supranational criminology and international crime. Jayesh was talking about the environmental law crimes and others. I would like to, I will not say congratulate, but appreciate the efforts of our young criminologist, dynamic person, Dr. Srikar Lama, who has put in a lot of efforts to organize this e-symposium on this important topic. As a president of Indian Society of Criminology, it is my duty to welcome you, because we feel really privileged and honored, because this is a platform where Indian Society of Criminology delegates and members, office bearers are communicating with the International Society of Criminology. And this should continue and it must go on. And I'm looking forward for future programs like it in coming days. Professor Madhavan, you see, he is very dynamic, active. Professor Omar, my secretary, our secretary, not my, our secretary of the Indian Society of Criminology, they are all concerned, because this is that golden jubilee year of the ISC. Every one of us is doing something or other. We want to make it sure that we are able to reach to most of the people who are having interest in criminology, and they want to contribute something for the betterment of the society, for the betterment of the criminal justice administration, whether it is national or international. Today's topic, though I am a student of law, and I usually say that I am a hybrid. I have worked in the area of criminology, and I am working in the field of criminology. And when I got this message from my friend Dr. Sika, okay, sir, we are organizing this e-symposium and the topic is international crimes. Suddenly, I thought that it's a very important topic, and especially for the young criminologists, for the students who are studying here, because international crimes are different. What we are teaching to our law students, law of crimes, because international crimes, they are the product of the Rome Statute. And this Rome Statute established 4 core international crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. Under the Rome Statute, the International Criminal Court can only investigate and prosecute the 4 core international crimes in situations where states are unable or unwilling to do so themselves. The jurisdiction of domestic courts, the court has jurisdiction over crimes only if they are committed in the territory of a state party or if they are committed by a national of a state party. Friends, the Rome Statute, the ICC's founding treaty, was adopted on 17th July 1998 by 120 states and entered into force on 1st July 2002, the date the code became operational. This date is very important, 1st July 2002. As of January 2018, 123 states are parties to the Rome Statute. The ICC outlines the key considerations for countries considering acceding to the Rome Statute. The court will exercise jurisdiction over the crime of aggression only once the terms of its definitions have been agreed upon by the countries supporting the court and formally amended into the statute. I think as a student of criminal law, it is my duty, and as well as I tried to find out the essentials of the international crimes. And international crimes share a structural resemblance with domestic offenses. They typically encompass two classical elements known from domestic criminal law, namely an objective and a subjective element. The material element, actus reus, encompasses objective elements relating to the crime, such as the illegal conduct of the perpetrator. It may be an act or omission. Its consequences, causation between act and consequence, and in some cases, specific circumstances related to the subject or object of the crime, such as minimum age of the victims or its modalities. The mental element, mens rea, describes the culpable frame of mind of the perpetrator. The individual requirements depends on the crime and degree of responsibility. They encompass cognitive elements, volitional elements, as well as certain forms of awareness of risk or negligence. In many cases, international crimes share commonalities with domestic categories of crime. For instances, offenses such as rape, murder, or torture can be found in domestic criminal courts. What makes international crimes distinct from ordinary domestic crime is the context in which they occur. It is factors such as the existence of an armed conflict or the systematic nature or scale of the violations. It may be in the contractual element that marks the difference to ordinary. We are having friends from several countries, and I think for me it becomes important to explain the Indian position on international crime. That is very important for our criminology students. India has neither signed nor ratified the Rome Statute of the International Criminal Court. It actively participated. The thing is, India participated actively in the preparatory committee for the establishment of the International Criminal Court and the United Nations Diplomatic Corps of Pelinoponterius on the establishment of the International Criminal Court, Rome Conference. However, India abstained from the motion to adopt the statute at the conclusion of the conference. India believes that if the ICC crimes of international concern, then terrorism must be included in the list of crimes. I repeat, the objection raised by the India at the time, it was that terrorism included in the list of crimes. It submitted two proposals for the inclusion of the terrorism. The first proposal sought to make acts of terrorism a crime against humanity and was complete with a definition of the act of terrorism. The second proposal wanted to include crimes of terrorism in the list of core crimes in the statute. The proposal left the definition of these crimes to be defined by the preparatory commission. India has suffered terrorist activities. Friends, those who are from other countries, they will understand the problems we have faced. And she has spearheaded the movement to get a comprehensive convention on international terrorism adopted at the United Nations General Assembly. It is that India sponsored a draft text for the proposed convention in 1996. This issue was, in other words, of importance to India. Rejection of the proposal was taken as a defeat. Yeah, I admit, at the time, the rejection of this proposal was taken as a defeat by the leaders.
Fine.
And
Before
it
it
was
destroyed, I'm very sorry. It is on now. Yeah,
please unmute your
I didn't see it before.
mic.
Okay.
It was a major factor in the
I
Indian
did.
decision
Thank you.
to abstain from the vote to adopt the Rome Statute. It was a major from the vote to adopt the Rome Statute. In many ways of terrorist acts around the world, since the adoption of the statute confirmed that India has addressed a real threat and problem in many countries. The issue may therefore have to be revisited also in the context of the ICC. It is, however, arguable whether the ICC could have jurisdiction over acts of terrorism should an appropriate framed situation come before the court. The Indian position towards the statute is not much different from that of other Asian states who have decided to not ratify based on their concern that it would lead to the dilution of their sovereignty. India is likely to ratify the statute in the near future owing to its concern regarding the primacy of the national jurisdiction. At the same time, India's current status vis-a-vis the ICC is what is always wanted. She presents the primacy of her national courts and still has to accept the jurisdiction of the ICC for a specific conduct or period. Thus, in discussions on the possibility of India ratifying the statute, the discourse, I think, should focus, if possible, because I know Indian scholars might discuss it, focus on if and when India may submit an Article 20 subclause 3 declaration, except it is only to come or acts of terrorism. Friends, as you international crimes, when we talk about them, whether it is genocide, whether it is crimes against humanity, or it is a war crimes or crimes of aggression, I know they are all important. But the thing is, unless today, if we are not realizing that how much challenging the crime of terrorism is, and the task of all nations should be to tackle this particular need. I congratulate this university. I think Sardar Patel University of Policy and the Criminal Justice, Jodhpur, and our collaborators who have provided this wonderful opportunity for virtual interaction with the experts, different fields, and who are working in the field of criminology. I hope that, like all of you, I'm also just waiting to hear what Professor Emilio Viano is going to speak. I conclude my remarks at this particular point, and hopefully Srikar will request Professor Emilio to start his deliberations, because it was really, I was personally very unfortunate at that particular time because I was just looking forward to hear him. Thank you, Srikar. Thank you very much. And I appreciate your efforts. Hope that this symposium will bring some very good outcome. I'm interested in outcomes, Srikar. Thank you very much.
Thank you, sir. Now I kindly request Professor Dr. Emilio Viano, the Honorable President of our International Society of Criminology, who is a professor at American University, Washington, and affiliated professor at George Mason University, to say a few words.
Dear colleagues, organizers, officers of the university and of the Indian Society of Criminology, speakers and participants in the world, my warmest greetings and best wishes from Washington as we open this important and original webinar on supranational criminology. It is especially symbolic, meaningful, and significant that this webinar is being held as we in different parts of the world have now been experiencing for several months a supranational event, the coronavirus pandemic, that is greatly impacting our lives, changing our lifestyle, and consuming much of our time, energy, and worrying. We are reminded of how polarized the world has become from all points of view and perspectives. This is nothing new, actually. Human history is punctuated supranational events, often connected, unfortunately, with conflict, war, and conquest that are often part of the history of our respective continents and countries, at times with alternating roles of victimizer and victim. The most salient difference today, quickly, vividly, and in real time, we can witness these events, war crimes, crimes against humanity, genocide, become aware of them, and take active part in reacting negatively or positively to them. Given the links that bind continents and countries, economies, manufacturing, food production, trade, research, studying, most, if not all, of what we do and discuss is supranational in nature, impact, and effect. Technology has an important role to play in studying, analyzing, researching, and calling for action when these supranational activity and events acquire a criminal nature by violating human rights, the law of nations, international treaties and conventions, indigenous rights, and the protection of the environment, to name areas. For all these reasons, this webinar is very welcome and valuable, since it is meant to stress this dimension of criminality, which is more and more the norm rather than the exception, the national nature of criminal activities. As president of the International Society of Criminology, I'm honored to participate and officially sponsor the event, I thank in particular Dr. Swikar Lama, the university, for their support of this important initiative. I congratulate organizers, the speakers, and the participants, and I wish complete success and a high impact to this original initiative. Thank you very much for the invitation. I'm honored to be among you for this webinar so important worldwide.
Thank you so much, sir. Now I kindly request Professor P. Madhva Soma Sundaram, Chairman of Indian Society of Criminology and the Department of Criminology and Criminal Justice, Mano Maniam Sundarnath, Tirunelveli, to address the gathering.
The of the Indian Society of Criminology, Professor Balraj Chauhan, the President of the International Society of Criminology, Professor Emilio Viano from the Jordan University, the Speaker for Professor Muhammad Matter, the Secretary of the Indian Society of Criminology, Dr. Syed Umar Hatab, the chairpersons of the various sessions, my good friend Dr. Riazuddin Mangul from the Rani Channamma University, Dr. Bajpai, Dr. Aravind Tiwari, the organizing committee members of this International E-Symposium, participants, ladies and gentlemen. It gives me great pleasure on the chairperson of the Indian Society of Criminology to collaborate with Sardar Patel University of Police, Security and Criminal Justice, Jodhpur, India, organizing this e-symposium on supranational criminology, dealing with national crimes. When we all know, when there are two involved in a crime, say for example, Bihar and Maharashtra, you know what I mean. Between Bihar and Maharashtra, the investigation becomes difficult. Now, when two countries are involved, then it becomes a huge thing for the investigation, for the jurisdictional issues, and sentencing process. So I think in terms of international crimes, the borders lose their significance, and we have a protocol, we have a process for it, but whether all countries are signatories to it, they have accepted it, this becomes an issue. So dealing with international by itself, like for example, human trafficking, carbon footprinting, terrorism, dealing with them is huge. So dealing with them is very, very complex. I think it leads to a lot of issues, more political than, so this always happens. And there are also possibilities where I feel really where cross-national crimes also deal with national two, three types of crimes also join together sometimes. We have today what is called as terrorism and narco-terrorism, where dealing with narco start funding the terrorism activities in the rest of the country. One of the unique forms of which has very recently happened in international crimes is basically the dealing with artifacts and idols of worship. We have lost a lot of idols from this country, and United Nations has had to send a document, an advisory about 2 years back, because this money is rooted and it flows to fund terrorism. This is why United Nations is also interested. So this is as far as the international crimes are. When we think in terms of supranatural crimes, one particular country, something happens and it has a butterfly effect on almost all other countries. Then it becomes even more complex. And for example, corona pandemic is one such thing. We are not sure which country, but it originated from, and today's telecommunications, today's migration, it is a possibility where it has got an impact, a butterfly impact on almost countries in the country. I think the organizers have chosen this topic in a very timely fashion as the president of the International Society, president of the Indian Society of Criminology both pointed out. I think the topic is very, very hot, and I think I should congratulate Dr. Swikar Lama and his organizing team for getting a galaxy of speakers from around the world for 2 days and conducting this program on behalf of the Indian Society of Criminology. I congratulate Dr. Swikar Lama, the organizing university, organizing committee. Thank you very much for your patient listening.
Thank you so much, sir. Now I request Dr. Swikar Lama, Organizing Secretary, for the deliver vote of the thanks.
Mrs. Sheetal Arora is there, my colleague, so she would be delivering the vote of thanks.
Am I audible? Hello?
Yeah, you're audible.
Yes, you're audible.
Good evening, everyone. It's a matter of great pleasure to present vote of thanks on behalf of Department of Criminology and Police Studies at Sardar Patel University of Police, Security and Criminal Justice, Jodhpur in Rajasthan. We are thankful to our patron and registrar of our university, Madam Mrs. Vanna Singhvi in Italia, who provided her support and encouraged us to organize this event. We extend our gratitude towards our collaborators in this event, the International Society of Criminology and the Indian Society of Criminology. We express a special thanks towards Professor Dr. Emilio Viano, the Honorable President of International Society of Criminology, who referred some resource persons for this event. We also express a special thanks towards Professor Balraj Johansa, the Honorable President of Indian Society of Criminology, who is also the Vice Chancellor of National Law University, Bhopal in Madhya Pradesh, Professor Madhav Somasundran, sir, Chairman of Indian Society of Criminology, who heads Department of Criminology and Criminal Justice at MS University in Tirunelveli, Dr. Sayyid Umar Altaf, Secretary of Indian Society of Criminology, for encouraging us to organize such events and contributing to the development in the discipline of criminology. We express our heartfelt gratitude towards our keynote speakers, Dr. Muhammad Matar, Clinical Professor of Law and Head of the Legal Skills Department at Patel University College of Law, Professor Greg Borick from Criminology and Criminal Justice Department of Criminology, Anthropology and Criminology in Eastern Michigan University, Professor George Richards from Department of Criminal Justice, Anthropology and Forensic Studies in Edinburgh University of Pennsylvania, Professor Dr. Jacob Barthuzin, President of Criminological Society of Africa, who heads Department of Criminology and Criminal Justice in University of Limpopo, Dr. Mike Arnold, Secretary General, World Society of Victimology, who is Vice President NGO Alliance Crime Prevention and Criminal Justice, Professor Gamil Popple, and Professor at Federal University of Bhea, Dr. Jorge Restrepo, an economist and who is also the Director of Conflict Analysis Resource Center in Colombia, for taking out time from their busy schedules and accepting our invitation for sharing their knowledge, immense knowledge in this event. We extend our special thanks towards the chairpersons of various sessions in this event, Professor R.N. Mangoli, Vice Chairman, Indian Society of Criminology, is also Director and Chairman of the Department of Criminology and Criminal Justice, Rani Channamma University, Belgavi, Professor J.S. Vajpayee, President, Indian Society of Victimology, who is Vice President, Victim Support Asia, and is also Vice Chairman, Indian Society of Criminology. He is Registrar in National Law University in Delhi. Professor Arvind Tiwari, former President of Indian Society of Criminology, presently Dean, School of Law, Rights and Constitutional Governance at Tata Institute of Social Sciences in Mumbai, Professor P. Madhav Somasundran, Chairman of Indian Society of Criminology, Head Department of Criminology and Criminal Justice at MS University, for accepting our proposals to chair sessions and giving their valuable time. We thank all the esteemed professors, academicians, practitioners, research scholars, and students from across the nation and India for becoming part of this inaugural session and participating in this event. At the end, we acknowledge the efforts of Dr. Chikalama, the organizing secretary of this event, Dr. Rupalji, organizing committee member, the members of student organizing committee, our UGC VRF research scholars, Jayesh, Anand, who have been immensely supporting us for managing this event. We acknowledge the efforts of our postgraduate students as well, Sameer, Shah, Anika, Mohit, and Chetan from DA Security for providing technical support and facilitating the continuing of the session. Thank you for joining us in this event. Thank you so much.
Thank you so much, ma'am. Now we will meet at 4:30 p.m. for the first session. Thank you all.
Thank you very
Good
much,
evening.
Dr. Sarkar. Bye bye.
Good evening, sir. Thank you so
I will
much.
be
Thank
one
you
of
to all and
next.
one and all, sir. Thank you so much, sir.
Bye,
Bye.
Dr. Sridhar.
Thank you,
Bye.
sir. Bye, sir. Thank you so much for coming. Thank you, sir.
Hello. The next session will be start in 15 minutes. The next session will be start in 15 minutes.
introduce you all to the chairperson and keynote speaker of this session. This session will be chaired by eminent Professor Riaz Ahmed in Mangoli. He has over 17 years of teaching experience and is currently presiding as the chairman of the Department of Criminology and Criminal Justice, Rani Channamma University. He is also the Dean of School of Criminology and Criminal Justice. He has completed one UGC minor research project titled Public Opinion of Police Performance, a case study of Dharwad district, and critical evaluation of public perception on decriminalization of adultery crime in India, a case study of Karnataka. He has edited several books and published about over 60 articles in journals of national as well as international repute. His area of specialization includes criminology, criminal law, correctional administration, penal policies, human rights and criminal justice system, security management, and research methodology. He has not only been conferred with the prestigious award of Fellow from Indian Society of Criminology at Patiala, Punjab in 2014, but with the prestigious award of Fellow of Indian Society of Victimology at Nirma Law University, Gujarat in January 2017. He is also the recipient of prestigious ISC Professor S.S. Srivastava Award for Excellence in Teaching and Research in Criminology at Madurai. It is an absolute honor to have you here with us, sir. The speaker for this session is eminent Professor Mohammad Matar. Professor Matar is a clinical professor of law, the director of Law Clinic, and head of the Legal Skills Department at Qatar University College of Law. His personal professional expertise is in comparative and international law. He has been recognized as distinguished international expert on anti-trafficking legislation. He has worked over 15 years in more than 75 countries to promote state compliance with international human rights standards and to advise governments on drafting and enforcing human rights laws. Dr. Matar has testified in the United States on the status of human trafficking around the world at various hearings. He has also testified before the Russian Duma, the Mexican Senate, the Inter American Human Rights Commission, and the Egyptian Parliament. He has taught over 5 to 6 international courses in trafficking in persons, labor law, corporate social responsibility, international contract law, investment and trade, and so on. Dr. Matar was an adjunct professor at the American University, Washington College of Law, Georgetown Law Center, and at Johns Hopkins University School of Advanced International Studies. He's a visiting professor at the International Institute of Human Rights in Strasbourg, France, the International Institute of Legislative Drafting in Louisiana, US, and at the Siracusa International Institute for Criminal Justice and Human Rights in Italy. He has many international reputed journals which include medical liability for trafficking in purpose for the purpose of human experiments on international standards and comparative models from Arab jurisdiction. He completed his doctorate of juridical sciences and masters of law from Tulane University, his Masters of Comparative Law from the University of Miami, and his license in droit from Alexandria University, where he still serves as non-resident distinguished professor of law. I take this opportunity to welcome our distinguished speaker. Now, I would like to hand over this session to Professor R. N. Mangoli, who will be assisted by Mohit Salvi, a student of Masters in Criminology and Police Studies, for question and answer session afterwards. Thank you, sir.
Uh, Good evening. Am I audible? Am I audible?
Yes, sir, you are audible, sir.
Okay, okay. Good evening, everyone. Indeed, it is pleasure and privilege for me to be the part of this International E-Symposium. First of all, I congratulate Dr. Svikar Lama and the team from the Department of the Criminology and Police Studies, Sardar Patel, University of Police Security and Criminal Justice, Jodhpur, for organizing 2 days international symposium, e-symposium, on a very important theme, that is supranational criminology, dealing with international crimes in collaboration with International Society of Criminology and Indian Society of Criminology. And this is the first session of the 2 days e-symposium on a topic, the transnational crime on human trafficking recent legislative development and challenges. To deal with this particular topic, we have amongst us a very eminent and renowned and internationally recognized expert, Professor Muhammad Matar. And just now, we have all heard about his the work, how he has been working for last 15 years for the almost he has assisting and advising more than 75 countries. Dear friends, when we speak about the transnational crime, we always find that human trafficking is very horrific, serious crime and a grave violation of human rights as a global phenomenon. Today, almost every country in the world is affected by this particular menace. Before handovering or asking the speaker to speak on a particular topic, I'm being the Indian criminologist. I would like to, give a brief background of how that India is fighting against human trafficking and what are all the provisions which has been scattered in different legislations that I would like to brief here, so that it will be very helpful for all participants to know that how India is facing this particular menace. We have different provisions which has been scattered in different legislations, starting with that the Constitution of India, Article 23(1), which prohibits trafficking in person, begging, as well as forced labors. Then come to the Immoral Trafficking Prevention Act of 1956, is the premier legislative enacted for the prevention of trafficking for the commercial sexual exploitation. Then we have criminal law, particularly the various sections, section 366A, 366B, and 370, 371, 372, and 373. That all covers about the procuring of girl and buying and selling of the girls, trafficking, etc. Then we have again very important protection of children from the sexual offense, POXO Act 2012, which is specifically deals with the protection of children from the sexual abuse and exploitation. We too have other laws and legislations which covers human trafficking are Prohibition of Child Marriage Act 2006, Bonded Labor System Abolition Act 1976, Child Labor Prohibition and Regulation Act 1986, Transplantation of Human Organs Act 1994. Even we have the Juvenile Justice Care and Protection Act 2015. Particularly here, I would like to quote that in 2018, Ministry of Women and Child Welfare, they have made an unsuccessful attempt to push the one more particular bill in the parliament that the trafficking of persons prevention, protection, and rehabilitation 2018, which has been written back because it has a lot of flaws and lacunas, and it has been asked to rethink and look into it. And India has also put lot of efforts in implementing international conventions. Like we know very well that India is ratified 2000 UNT TLP Protocol 2011, as well as India became the signatory to UN Convention Against Transnational Organized Crime UNTOC, and its three protocols to prevent, so to suppress and to punish trafficking in person 2002. India has also ratified SARC Convention on prevention and combating trafficking, particularly women and children. So with all this, India has continuously putting a lot of effort to control this particular menace. India has also established the anti-trafficking cell, which communicating its various decisions and follow-ups on action taken by the state governments as well as the union territories. Ministry of Home Affairs has issued many advisories to all the states and union territories, as well as launched a very important anti-human trafficking web portal during 2014. And friends, not only that, India is also putting a lot of effort in training and capacity building to strengthen law enforcement response against trafficking in person, particularly the police officers and prosecution at the regional level, and even it conducts judicial colloquium to train and sensitize the trial court judicial officers. So, my dear friends, despite the numerous significant efforts and measures taken by the government of India to prevent and punish those who are involved in human trafficking, it is allowed to say that it is still omnipresent and it is continuously happening across the country. So, on the other side, one more thing I would like to bring to all your kind notice, that on the other side, Supreme Court of India, from time to time, on its various decisions dealing with the missing of children, human trafficking, bonded labor, child labor, etc., have given a lot of guidance for the strict enforcement of law to combat this menace. Particularly here, I would like to quote a very important Supreme Court ruling in Buddha Dev Karmaskar versus State of West Bengal in 2011. Supreme Court has constituted a panel of activists, NGOs, and lawyers to study the gravity of the human trafficking issues of missing of women and children in India. Further, the said panel has asked the Apex Court to direct the NCRB, National Crime Record Bureau, to compile the data on missing of children and women to identify the area prone to the trafficking. Resultantly, in the year June 2019, NCRB has submitted its report on missing women and children in India. It's really, if you see that report, it is available on the NCRB website. It's very alarming one, and it is shocking one, that from 2016 to 2018, it has become, the trend is showing that continuously it is increasing. Let me quote here. In 2016, it is the missing of female is reported 1,75,000, say almost 1,74,000. Whereas in 2017 it is reported 1,88,000, and in 2018 it is reported 2,23,000. So like that, this particular human trafficking, offenses, human trafficking crime, and the missing of the female is continuously increasing. If you tally this to the crime watch, more than 600 women and 180 children go missing every hour in India. Is this not alarming? Is this not shocking for all of us? So, my dear friends, with this particular this thing, there are that even UNDC global report 2018 on trafficking indicates that the vast majority of detected victims trafficking were females for sexual exploitation. So, under the circumstances, we have many challenges ahead. Because what are the few challenges I would like to bring to your kind notice from the Indian scenario is that there is a lack of proper awareness in the general public. Public doesn't know that what constitute exactly the trafficking, and the lack of proper training to the police personnel to handle such cases meticulously, the lack of proper rehabilitation program for the victim of trafficking, and under the circumstances, I would like to seek the very eminent speaker, Muhammad Matar, would like to advise us with your valuable suggestions from from the today's particular topic, that how to make progress, and what are the specific strategies, how to move forward to combat the human trafficking menace effectively in India. So thank you very much. With these few words, now I request Muhammad Machar to please take mic, and you please proceed. Now over to Muhammad Machar. Sir, please unmute. Please, sir, please unmute your mic, sir. Please unmute your mics, please. Sir, please unmute your mic, sir, please.
Hello. Sir, you are inaudible, sir. Hello. Hello, sir, you are inaudible. So you need to remove the mic, unmute button.
Professor Muhammad Matar, please unmute your mic, please. Sir, still it is not audible.
Hello. Sir, you are inaudible, sir. Sir, your mic is on mute.
Professor Muhammad, sir, it is not, your mic is, yeah, now you can speak, sir.
Yes, sir, yes.
Now it's
No, I don't,
fine?
yeah,
Yes,
now it is
fine.
fine.
Okay,
Please proceed,
Bismillah
please
ar-Rahman
proceed.
ar-Rahim. Thank you, Professor, very much, and thank you for this very kind introduction. Really delighted to participate in this international symposium on international crimes or transnational crimes or supranational crimes. I have to confess, I do not know the difference between the three, but I'll focus on the international crime of human trafficking, an international crime that was defined by the International Criminal Court as a crime against humanity. A few months ago, before the coronavirus crisis, I was privileged on behalf of the Qatar University College of Law to host the International Society of Criminology 2019 Congress back in October 27, I still remember. So I have to start by sending greetings to my very good friend, very special greetings to Professor President Emilio Viana. Always a pleasure to work with you, sir. And my greetings also to Dr. Srikar Lama. I didn't know that you are that young, very young, but I received tens of emails from you, and it helped really to put this lovely event together. So thank you, Professor Lama, very much. And also greetings to this very special University of Police, Security and Criminal Justice of India. And I am no stranger to the great state of India. Back in December 2013, and right before Christmas, with the Global Alliance for Justice Education, I participated in the 7th Worldwide Conference in New Delhi with the National Law University and Jindal Global University, and we put together a conference on clinical legal education. For those of you who know me, I'm a big believer in clinical legal education. This coming semester, fall 2020, we're going to start perhaps in August 16 online and maybe move to person-to-person classes sometime in September. I am organizing a project on the legal implications of the coronavirus crisis around the world, a global problem that required global responses. So I put together a project with almost 20 plus clinics from around the world, from South Africa to New Zealand to US to Australia. And we're going to examine the criminal liability for transfer of the coronavirus disease. We are going to examine the criminal liability of a hospital that fails to provide safety and protection to its medical teams. But we are going also to examine the human rights implications of the coronavirus crisis. Why is it affecting more blacks than white in the United States? Why is it affecting more migrant workers here in Doha than nationals, and so on? So if you have a clinic or if you have a class that would be interested in doing some work with partners of the law clinic at Qatar University College of Law, please send me a note. Dear Professor Matar, I would love to join that project, and I'm interested in perhaps getting my students to work on the legal implications of the coronavirus crisis and we are going to be comparing notes. November 30th, we're going to have an e-conference, and then in December, we are going to publish a report that will cover responses from different countries in the world. And in Doha, Qatar, a few weeks ago, 7 were arrested. So 7, we're talking about an organized criminal group. They were arrested during the coronavirus crisis for recruiting mainly domestic workers, but also workers that did not have any legal status, to perform beauty services at homes. As you know, up until maybe yesterday, beauty salons were closed. So a trafficker or traffickers took advantage of the situation and started recruiting domestic workers and other workers to do work at home. Is this a form of human trafficking? Well, there has been an expansion on the concept of the crime of human trafficking. Yes, sex trafficking is a form of trafficking. Yes, labor trafficking is another form of trafficking. But the United Nations Protocol to Prevent, Suppress, and Punish Trafficking in Persons, which supplements the United Nations Convention Against Transnational Organized Crime, talks about different types of exploitation and leave it up to the particular state to add any type of trafficking that is common in a country. So, using prisoners, for example, in violation of the Nelson Mandela's rules of 2015 on treatment of prisoners, to conduct medical or scientific experiments, that maybe would be a form of human trafficking. And it is in some laws, in some parts of the world. Human experimentation in that sense is a form of human trafficking. Also, recruiting a young fellow in Syria or in Libya or in Yemen, and they're all suffering as we speak, to commit an act of terrorism, again, is a form of human trafficking. And it is mentioned in some laws of some countries, like, for example, Lebanon. When you take a look at the Lebanese law, it talks about recruiting a person to commit an act of terrorism, and that would be considered a form of human trafficking. So how about India? And let me go for India and consult the United States Trafficking in Persons report that was released this last June 2020. I'm sure some of you watched Ivanka Trump introducing the report on June 25th. I'm not sure she will be doing the same in June 2021. So let's wait till November to find out. India is placed on tier 2 on the TIP report, the Trafficking in Persons report, for the 7th time since 2013. What does this mean? It means that according to the US, India does not fully meet the minimum standards for the elimination of trafficking, but India is making significant efforts to do so. And I was asked, what else should be done to combat the problem in India? According to the report, the largest trafficking problem is the internal forced labor, especially bonded labor, especially debt-based coercion, compelling women, children, men to work in agriculture, in textile factories and other places. And also the report talks about exploiting Indians internally in commercial sex within India itself. So you have both types of human trafficking. You have labor trafficking, you have sex trafficking. But also the report mentions transnational trafficking, when traffickers recruit Indians to go and do work in Gulf states, the 6 Gulf states. And Indians, there are too many Indians here in Doha, Qatar, and they may become subject to what is called the kafala system, the sponsorship rule. So you have an Indian, he comes here, the first thing that happens to him, his passport is confiscated in violation of the law. Let me be fair here. All the laws in the 6 Gulf states prohibit retention of IDs or travel documents. But in practice, this happens all the time. So an Indian comes here to Doha, starts working. Well, he does not have too much leverage to negotiate the terms of the contract. In fact, he is faced what is called contract substitution. So he's promised something in Delhi, in India. He comes here and then he finds out that he is faced with very different terms and conditions of the contract, whether we're talking about salaries or we're talking about hours of work. And then if he does not like his employment, he does not like his employer, he cannot transfer to another employer during the term of his contract. He has to obtain the consent of the employer. So these are all indicators of what we call labor exploitation. The question in these countries is, how does labor exploitation become a form of a crime of labor trafficking? How we distinguish between a breach of an employment contract on one side and the crime of human trafficking on the other side. I make the case that for the crime of human trafficking to exist, you need an independent act, a tort, a crime, a violation of the law. So if you have a worker and then you are denying him his right to movement, not only that, but you are beating him. So this is a battery, this is a crime, and you are maybe sexually exploiting him and so on. So if you have, in addition to failure to pay salaries, you have an independent act that constitutes a tort, a crime, or violation of the law, that's when the labor exploitation rises to the level of the crime of human trafficking. But that's not the only report that is published by the US. The US is a rich country and they publish reports all the time. You have a human rights report in February, you have the trafficking report in June, but there's another report that is really important for our purposes, and that in 2005, the Trafficking Victims Protection Act was amended to require the Department of Labor to publish another report. It is called a list of goods produced through child labor and forced labor. Almost 148 goods from almost 76 countries in the last report were listed as goods that are produced through child labor or forced labor. Let me focus on India because India is all over the report. The report mentions that the following goods in India are produced by child labor. Hand-rolled cigarettes, bidis, I don't know what is this, brassware, cotton, fireworks, footwear, gyms, glass banglers, sugarcane, leather goods, matches, soccer balls, and so on. So, if you're asking me what should we do about human trafficking in India, it's not enough to address sex trafficking and commercial sexual exploitation. We have to look into production of goods through child labor and forced labor. And I want you to take a look at the Department of Labor report. So two reports are important for our purposes, the State Department report and the Labor Department report. Two are really important. That happened in 2005. The Trafficking Victims Protection Act was amended, requiring producing this list of goods. But that's not the only change made in the U.S. Trafficking Victims Protection Act. I'm going to mention some which are relevant for our purposes here, not only for the U.S., but for the world. In 2003, and for the first time, the act was enacted in 2000. In 2003, that was the first change. It created a new civil action that allowed victims of trafficking to file lawsuits asking for compensation before federal district courts. Up till 2000, there was nothing called a civil action. And you all know, for a victim of trafficking to ask for compensation, to be compensated, there are 5 main means. They differ from one country to another. Some countries have what we call a state fund. So Bahrain, for example, establishes a state fund. The state fund can compensate a victim. In Tunisia, they have a good law. It says that if a victim of trafficking gets a judgment and she gets some kind of compensation, the state itself pays the compensation and goes after the trafficker. Again, that's a good best practice. So if you're asking me, how about India, I would tell you it's a good idea to take a look at best practices around the world. Bahrain was mentioned for the 3rd consecutive year as a tier 1 country. It's good to take a look at the 30 plus countries that are put on tier 1 and ask the question, what are they doing really that is helping? And perhaps the second question would be, how can we utilize some of these good practices in our own country, like in India? A second way of compensation is forfeiture of assets. Every legal system, you have the proceeds of the crime. Can you use these proceeds of the crimes to compensate the victims? Some countries do, some countries don't. The third is what we call mandatory restitution, which a judge would have in a criminal court. So while he is looking into the criminal action, he would issue a judgment in favor of a victim of trafficking, what we call a mandatory restitution. And then a fourth really important way is what we call punitive damages. I know that's not common in every country, but in the United States, punitive damages may be awarded in cases of human trafficking. And then finally, as I mentioned, the civil action. 5 main means of compensating a victim of trafficking. But that's a change that took place in 2003. In 2005, really an important change also happened. The Iraqi War, and we're all very familiar with the Iraqi War, 2004, 12 employees from Nepal, 12 men from Nepal were recruited to do work in a hotel in Jordan. They ended up in the American US base in Iraq. We don't know how, but they were promised they're going to Jordan. They took them to Iraq during the war, and the 12 of them were killed by some militants. And the question at the time was, can we apply the US law on extraterritorial basis? And the answer was no. The US applies only to acts that are committed within the territory of the US. So Congress intervened, changed the Trafficking Victims Protection Act, moved from territoriality to extraterritoriality to remedy this situation. In 2008, the law again was was amended to remedy another situation, and that was diplomats in the US. They love inviting people for parties. They don't cook themselves. They hire domestic workers, and the question would be, can you hold a diplomat liable for abuse of a domestic worker? Can you hold a diplomat liable for trafficking for the purpose of domestic work? And the answer in 2008 was no. A very famous case, El Saleh, who was from Kuwait, he brought with him to the US a domestic worker, abused her, and in court they could not prosecute him. And the court said, unfortunately, the Trafficking Victims Protection Act shall not circumvent the Foreign Sovereign Immunities Act. We cannot do that. Foreign sovereign immunity would prevail. So the court said, if you want to change that, go to Congress and let them change it. Congress intervened and changed the law, and now you cannot still prosecute. So change the law. How? They shifted the focus from prosecution to prevention. And a very interesting concept, new one, it says that if an international organization, let's say World Bank, or a mission, an embassy, let's say the embassy of Kuwait, and some of their employees are abusing domestic workers, nothing is being done about it, credible evidence mounting that this is the case, the State Department may deny these international organizations and these missions the right to receive an A3 visa. So if you cannot prosecute, no problem. We're not going to let you have domestic workers at all. A shift from prosecution to prevention, a nice one that took place in 2008. In 2013, again, another very interesting change that happened, which is also important for our purposes. The act said we are going to prevent any foreign aid to a country that is utilizing, facilitating child soldiers. And as you know, the United Nations tell us that there are about 14 countries that are big on child soldiers. Of course, Arab and Muslim countries would be on top. You can think about Afghanistan, you can think about Iraq, you can think about Sudan, you can think about Syria, you can think about Yemen. So the law changed here and said we're not going to give, because that's trafficking for the purpose of using children in military purposes, another form of human trafficking, and we will not allow it. In 2017, a very interesting concept, victims of trafficking who receive compensation were still exempted from paying tax. I just want to remind myself that I did not pay the tax for this year. I have an extension till October 15. In 2018, a new law that is very fascinating was also enacted, very important also for our purposes. April 11, 2018, President Trump, yes, he's still president up till now, signed into law what is called Stop Enabling Sex Trafficking Act. Stop Enabling Sex Trafficking Act aimed at websites that enable the crime of human trafficking to occur online. As you know, sex tourism takes place online, marriage by catalog takes place on pornography online. Initially, I remember when this law was out, there was a bill, the Internet Association, which presented Facebook and Google and Microsoft and all these cute little websites, they voiced opposition to the bill, and then they said, okay, it's fine with us. Now, online service providers are no longer immune from liability for victims of their users. Very important development in the area of human trafficking. You're talking about cyber crimes, you're talking about crimes, electronic crimes, you're talking about crimes that take place on the internet. That brings me to some policies that I want to emphasize with you in the area of crime and punishment, criminal justice. I have 5. What does this mean? It means that you can have the crime of human trafficking if it happens internally. And this is the case in India. There are too many cases of human trafficking inside India itself. And you don't need organized criminal group. You don't need 3 or more. You can have husband and wife doing prostitution and doing with prostitution, recruiting young girls for sex trafficking. That is another form of trafficking. So this is a really important point to make. However, the organized criminal activity or the transnationality may constitute what we call aggravated circumstances that enhance the penalty. So if you have 10 years, it becomes 15, you have 15, becomes 20, like corruption. If the one who is committing the crime of human trafficking is a public official, it enhances the penalty. Like if the traffic person is a woman, in many countries around the world, if the traffic person is a woman, you enhance the penalty. So that's really an important point to make, that transnationality, organized criminal activities are not elements in the crime of human trafficking. They are only aggravated circumstances that enhance the penalty. The second point that I want to make is regarding plea bargaining. Plea bargaining, as you know, is very common in the United States. Almost 90-95% of the cases in the US end with plea bargaining. You don't go to trial. And I always made the case, and have been making this case for some years now, that plea bargaining should not be allowed, and it's not appropriate in cases of sex trafficking that involve children. You are all familiar with the Jeffrey Epstein case and Alex Lacosta. Alex Lacosta was a friend of mine. He was the Attorney General of Florida. In 2008, he entered into a plea bargaining agreement with Jeffrey Epstein to avoid federal charges. They told him, okay, you're going to spend 13 months in jail, plead guilty to solicitation of prostitution of a minor, and you are going to be allowed even to go and do some work. You don't have to stay in jail all the time. Amazing plea bargaining agreement took place. Now, as you know, this last year, he was arrested again. Alex Lacosta, who became the Secretary of Labor, had to resign because mounting pressure against him. How could you do that in 2008? And Epstein himself committed suicide. And then this last July 18, his mastermind, Ghislaine Maxwell, was arrested. The names of Bill Clinton surfaced, and Prince Andrew were there at the time, and so on. So a big mess. And I am, again, for non-application of plea bargaining agreements if you have a case of human trafficking, sex trafficking that involve children. Exactly like I'm with no prescription, no statute of limitation if you have a case of sex trafficking that involves children. And this is now the case in many countries around the world. If you have a case that involves sexual crimes and against children, you can file the lawsuit anytime. There's nothing called a statute of limitation when you have a crime that involves sexual crimes against children. Third, should we punish the customer? Should we punish the customer? Should we punish the client? Should we punish the purchaser of sexual services? We go after the trafficker. But how about the customer? The one who is entering into some kind of a relation with a woman in prostitution. Would he be liable for prostitution? That's not my issue. I'm asking, would he be liable for sex trafficking? Should we prosecute demand? And we have an answer in Article 19 of the Council of Europe Convention on Action Against Trafficking in Human Beings. Under Article 19, a fascinating article, it says state parties shall consider criminalizing the use of services provided by victims of trafficking if the user has knowledge that the person who is offering the sexual services is a victim of human trafficking. Are we criminalizing prostitution here? The answer is no. You don't criminalize prostitution in Italy or in France or in Germany, or you don't. But what we are doing here, we are going after the customer if he has knowledge that the person who is giving him the sexual service is a victim of human trafficking. Of course, it's difficult to prove, yes, but if you have an act that is difficult to prove, does not mean that you don't criminalize such an act. And we do not really rely on actual knowledge. We rely on what we call constructive knowledge, and that's why the criminal law is so. If we say if he knows or he has a reason to know, constructive knowledge would be enough. The fourth observation in the crime and punishment criminal justice policies is that we have to go after the legal person, the moral person, the corporate person, the juristic person. I am referring here to Article 10 of the Organized Crime Convention. It talks about liability of a legal person. It says, well, it's not enough to go after the natural person. The legal person should be also liable. Article 10 of the Organized Crime Convention. So we have to go after the recruitment agency. They may be the problem. And they would be held liable for labor trafficking. They go after the poor, vulnerable employee. They let him pay recruitment fees. They recruit him for the purposes of labor. They are, if they are complicit, they should be liable. Article 10 of the Organized Crime Convention. Similarly, with travel agency, we're having what we call child sex tourism. Child sex tourism is a problem, and it's a form of human trafficking. So if the travel agency is complicit, let's go after the travel agency. Similarly with adoption. And as you know, the US is number one in adoption. The US is number one in everything. So I don't know whether it will continue after coronavirus crisis will be the same. But adoption, we have to go after the adoption agency if the adoption agency is involved in trafficking for the purpose of inter-country adoption. Similarly with matchmaking organizations, what we call marriage by catalog. There is a law in the United States called the International Marriage Broker Regulation Act. If you are bringing somebody from India, from the Philippines to the US to be married to a US citizen, at least reveal, disclose his criminal record. So when she comes, she knows what she's doing. Was he married before? Does he have children? Okay, no problem. But does he have a criminal record, domestic violence, and so on? We have to go after the marriage broker and so on, with what we call mail order bribe. So liability of the legal person is really important. First and finally, and that's the most important part of the human rights-centered approach to human trafficking, do not punish the victim. This is the principle of non-punishment of the victim. Unfortunately, in many countries around the world, the victim is punished for prostitution. She comes forward and testifies and say, no. What were you doing the last 10 years? Prostitution. You're not a credible witness. And that's why some law says past sexual services of a victim of trafficking shall not be admissible in court. But do not punish the victim. That is a principle which is really important. Non-liability of the victim for even a related trafficking offense. So violation of immigration law, violation of labor law. And of course, if she commits an act of trafficking related to the trafficking itself, she was compelled to do so, she should not be liable. I am going to refer here and end with Surah Al-Nur 24-33. The Quran says, and do not force them into prostitution, and if they are forced, do not punish them. God will forgive them. Inna Allaha Ghafurun Rahim. Thank you so much for listening.
Thank you so much for such an engaging and insightful session. We would now be taking some questions and answers.
I cannot hear you well, by the way.
Hello, am I audible? Hello? Hello?
Yeah, it's audible.
Hello?
Yeah, you're
Yeah,
audible.
Nika, continue.
Please continue.
So thank you so much for such an insightful and an engaging session. This was very informative. And we would now be taking some question and answers from our audiences. So Mohit will be assisting you in this question and answer round. Mohit, over to you.
Can you repeat? I cannot hear.
We will be now taking questions and answers from our live audiences now.
Excellent. Okay.
Thank you, sir. Thank you so much for this wonderful session. As you all know that we are also live on YouTube also. So we have a lot of questions from YouTube audience as well. So there is a first question or request from Ankita Shukla, that is put some light on laws related to health of female sex workers and transgender. Is there any specific healthcare related laws for the same?
Okay, that's a good question. Of course, I am not sure that I use the term sex work or sex workers. Some do, some don't. Whether sex is a type of work, it's debatable. Some countries do not allow it. And that's why for the protocol, it talks about exploitation or prostitution of others. It does not talk about prostitution as a form of human trafficking, to make that distinction clear. While if you take a look at the Arab Charter on Human Rights, it talks about both. It talks about trafficking shall include prostitution and exploitation or prostitution of others. So the act of prostitution itself may constitute a form of trafficking, and in addition to the exploitation or prostitution of others. Healthcare is really important, and I remember when the Trafficking Victims Protection Act was put together, we in academia called for a change in the law. I remember Article 112. Article 112 says that we need some research in different areas. One of the areas that we wanted research in was the health implications, the global health implications of human trafficking. We need to know a little bit about that. That's an area which needs more work to be done. And that's why when we define the vulnerable person under the United Nations principles and guidelines on access to legal aid in criminal justice system, and also when we define the vulnerable person under the United Nations Global Compact on safe, orderly, and regular migration, we said if a person who contacts HIV/AIDS or other health problems, he becomes vulnerable as well. This vulnerability is very well highlighted in Muslim countries. So if you have a woman in prostitution, can she come back and be integrated in the society? Very difficult. What if she has a health problem like HIV/AIDS? So very difficult for her to come forward and report on her condition. So yes, absolutely, we need health protection. And I mentioned that in my coming project, and hopefully you have a clinic or a class that would be interested in clinical work, we are going to look into the health implications of the coronavirus. Some good writings. Professor David from South Africa just published an article on the health implications of the crisis. So human trafficking and health, absolutely really an important area to explore. If you take a look at the trafficking laws themselves, they were developed in isolation of all these other laws. Very fascinating concept. For example, the trafficking laws were not, the whole concept of trafficking did not develop as part of the human rights law. It developed as part of the International Criminal Law. That's why the protocol was part of the Organized Crime Convention. You need to address the problem by addressing, but what we call a multidisciplinary approach, by addressing all aspects of the problem. Definitely, immigration is one of them, health is another one.
Thank you, sir. So next we have a question from Prerna. That is, what are your thoughts on decriminalization of sex work? Can acknowledging it as a form of work reduce the trafficking and smuggling?
Which form are you talking about? I missed that.
I'll repeat the question. What are your thoughts on decriminalization of sex work? Can
No,
acknowledging
I didn't
it...
get the word. Can you see the word again? Legal what?
Sorry?
Illegal migration?
Decriminalization of sex work.
Illegal migration of sex work?
Decriminalization of sex work.
Legalization.
Decriminalization.
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 Yeah, decriminalization.
Okay, decriminalization. Well, again, let me make myself clear. Let's not talk about prostitution and trafficking at the same time. These are two different issues. I'm not going to look into or make a statement regarding decriminalization of prostitution or legalization or criminalization. That's not my issue. My issue is exploitation. My issue is human trafficking. So I'm not going to make a statement regarding the policy of a country regarding the criminalization of sex work and so on. What I am concerned with is human trafficking itself. If you allow prostitution, fine, but you do not allow exploitation of prostitution. That's the point. I like court cases, and I want to refer you to the United Nations database on cases of human trafficking. I remember in 2011, we went to Vienna, we had 7, 10, 12 cases. Now we have over 2,000 cases, and it's really interesting to take a look at court decisions from different countries around the world. I like a judge who said, yes, she consented to prostitution, but she did not consent to who she's going to have prostitution with, you know? So here we talk about informed consent, free consent, and so on. So prostitution is an issue that I'm not going to get into it. What I would like to always emphasize is that avoid exploitation in all cases. Whether you're talking about marriage, you know, I get the question all the time, how about arranged marriage? How about temporary marriage? How about marriage by catalogue, mail order bride? Well, marriage is not my issue. I'm not going to come and make a statement, this marriage is right, this is wrong, this is legal, this is illegal. However, if marriage, any type, entails an element of exploitation, it may become a form of trafficking. So leave prostitution alone. Let's talk about human trafficking. Let's talk about sex trafficking, and let's think about prostitution. I would make the case, for example, in my opinion, that if you outlaw prostitution, that will be a preventive measure that will help with human trafficking. So the total opposite opinion of others that you decriminalize prostitution. In my judgment, U.S. Prostitution is illegal. So to me, that's a preventive measure. Would it eliminate the problem altogether? The answer is no, but I think that's my own opinion. You got me to say my opinion. It should be illegal. And it is one of the preventive measures that can be taken to remedy the problem of sex trafficking.
Thank you, sir. So there is no more question on YouTube. So I'll hand over to Anika now.
Thank you so much, sir. Am I audible now?
Yeah, you are audible.
Thank you so much, sir, for giving so much food for thought to all of us. Now, I may please request Dr. Srikar Lama, the organizing secretary, to deliver vote of thanks.
Can you repeat the question? I did not hear it.
Hello. No, sir. She was just asking me to give the vote of thanks. Professor Manguli, would you like to add something?
Yeah. Sir, overall, it's an excellent talk. And particularly, you are very particular about specifically that to avoid exploitation of laborers, bonded labor, and trafficking. And 2-3 suggestions you have made very prominently, which that even India should look into it. Particularly that you have suggested us, India, that we should need and imitate the best practices around the world who are dealing with human trafficking. That really, that is really touched. And one more thing you have actually suggested that the state funds should be established to compensate the victims of trafficking. That is also been noted down. It's very important suggestions. And particularly, you also told that there should not be punishment for the victim of trafficking, and you have tried to tell the many possibilities to prevent the human trafficking. And there is also no question of pre-bargaining in case of sex trafficking. So overall, that as you suggest, as India is still continuously on tier 2 with respect to trafficking, even as per the US State Department released in 2019. So keeping in all those things, we are actually in India, the MHA has already constituted a committee, high profile committee to reform criminal law. I think it will be very helpful for us to suggest them to incorporate these things. Thank you very much.
Okay, you're raising too many points, and you are definitely right, because we're talking about a very complex problem, and to address it, to combat, or to try to do something about it, we need what we call a multidisciplinary approach. We are, of course, familiar with the 4 Ps: prevention, protection, prosecution, and partnership. I call it participation, but because I'd like to see a role for the ordinary person, so I call it participation. Every one of us has a role. Prevention to me is really important. It has something to do with culture. Last week, I was part of a summer course in Miami. St. Thomas University has a course on human trafficking Professor Rosa there established an academy on human trafficking. And this year I spoke about harmful cultural practices, how they create an infrastructure for human trafficking. Harmful cultural practices must be addressed, what we call traditional practices, customary practices. And I think this is part of the problem in many cases of human trafficking. The UN Protocol in Article 9 talks about 3 causes of human trafficking: poverty, underdevelopment, and lack of equal opportunity. Harmful cultural practices is a problem. So here we're talking about education, public awareness campaigns, a role for the law clinic, a role for academia. This particular symposium, I would consider this as a tool, good tool to raise awareness about the problem. Academic institutions play a role. The private sector, I just mentioned production of goods in India through child labor and forced labor. The private sector has a role to play, a really important role, and it's a preventive role, and it's really important. Religious institutions, I'm a big believer also in a role for religion. So if you have a fatwa, a legal opinion given by a Muslim scholar on the abuse of domestic workers, for example, maybe that will have some influence. So if you're thinking about prevention, I think prevention becomes really an important aspect of dealing with the problem. But our main problem in the area of human trafficking is prosecution. We have a low rate of prosecution in most countries around the world. What is I don't know, maybe we're not allocating enough funds to address the problem. Maybe the judges, lawyers, law enforcement officials need more training. I was in India, by the way, a while ago, also participating in some of these trainings. But prosecution is really, again, important element. Deterrence is really important. You have to go after can you go after a public official? Difficult also. But you need to go after those who are committing the crime, whether it is a private person or a public person. You have to go after corruption. So back to the big picture, there's no one easy answer, and there's no one answer. You have to think about multidisciplinary approaches. But, and you mentioned that in your intervention, in all cases, do not punish the victim. She should be treated with respect. She should be treated with dignity, and do not punish her. In many countries, she's being arrested. In many countries, they even deport her. And as I mentioned, in many countries, she cannot even testify before the court, and her testimony would be considered credible. And that's why I always call for really a very important principle: do not rely totally on the testimony of the victim.
Sir, thank you, sir. Thank you very much. Thank you, Dr. Lama, for giving the opportunity to chair this very important session. Thank you very much.
Thank you, sir. First of all, I would like to thank Professor Aryan Mangoli, sir, for chairing the session. As this is a virtual platform, we are unable to present you any memento. So we are just, as a small token of gratitude, we are presenting your certificate of appreciation, which we are putting up on the screen. Jayesh?
Thank you.
I did not get is this a comment or a question?
Comment, sir. Comment.
Okay, comment.
Just a word of thanks. Okay, sir.
Word of thanks.
Okay, and now I would like to thank Professor Mohammed Matar. As you say in Qatar, shukran. Thank you for giving us your knowledge and information and your time, precious time. And we would also like to present you a certificate of appreciation, a small token of gratitude for giving us your time and knowledge. Jayesh, please
Thank
go
you
on.
so much. My pleasure. And I'm really happy that you're putting this together. Keep the good work. And
Thank you so much.
very proud of you all.
Okay. And now I would also like to thank the other speakers who are still here, Professor Emilio Gano and Professor Greg Barak, who have been here since 6 o'clock in the morning in USA. And we also have Professor Dr. Jacob Arkaza and Dr. Michael O'Connell out here, who have been there listening very carefully to the sessions. And I would also like to thank Professor Madhav Somasundaran, sir, Chairman of Indian Society of Criminology, and all my fellow academicians. I can see they are from all over India. And I would, at the last but not the least, I would like to thank the volunteers, research scholar Jayesh, my students Samir, Shashank, Anika, and Mohit for contributing and helping us to organize this session. Thank you all. Thank you so much. Thank you, sir. We will meet for the next session at 6 p.m. Thank you. Join us there. Thank you so much.
Just after 15 minutes.
I would really like to apologize to interrupt the hearty session that is going on. I would like to start again on behalf of Department of Criminology and Case Studies, Sardar Patel University of Police, Security and Criminal Justice. I heartily welcome you all to the second session of the International E-Symposium on Supranational Criminology dealing with international crime. So, without wasting any more time, I would like to introduce you all to the renowned academician and chairperson of this session, Professor G.S. Bajpai. Professor G.S. Bajpai not only serves as Professor of Criminology and Criminal Justice, but is also the chair at P.L. Arora Chair in Criminal Law at National Law University, Delhi, and is currently presiding as the chairperson at the Center for Criminology and Victimology. He is also the registrar at National Law University, Delhi, prior to which he was professor and chairperson at the Center for Criminal Justice Administration from 2007 to 2011. He's serving in National Law University now and has many academic accomplishments to his name. He has authored over 15 books, 80 papers, 10 project reports, and numerous monographs. Among many awards, Professor Jodhpur has received the ISC Kumarappa Reckless Award at the 40th All India Criminology Conference held at GNLU Gujarat on 19th January 2018. This is the highest honor and award given by ISC, acknowledging his excellent contribution in the field of criminology and criminal justice. He has not only received the Kumarappa Reckless Award, but also been conferred with the Professor K. Chokalingam Award at the 4th International and 8th Biennial Conference of Indian Society of Victimology. He has worked as a co-principal investigator of MHRD UGC initiative, the EPG Pathshala project in 2016. He single-handedly spearheaded this prestigious project, leading and overseeing the creation of hundreds of online e-texts and video lectures. I extend my gratitude to a man of his stature for bestowing his presence today. I would now like to invite our first speaker for the session, who is a preeminent academician, Professor Greg Barrett. Welcome, Professor. He's a professor of criminology and criminal justice at Eastern Michigan University and a former visiting distinguished professor in the College of Justice and Safety at Eastern Kentucky. He is one of the key players of supranational criminology. In 2003, he became the 27th Fellow of Academy of Criminal Justice Sciences, and in 2007, he received the Lifetime Achievement Award from the Critical Division of the American Society of Criminology. He was also the EMU recipient of the Roland Collins Distinguished Faculty Award for Scholarly and Creative Activity, which was awarded to him in 2006. In 2017, he had a Fulbright to Porto Alegre, Brazil, where he gave series of public lectures on globalization and crime, and gave a semester-long seminar on global criminology to masters and PhD students in criminal science at Pontificia University. In 2019, he received the Praxis Award from the Division of Critical Criminology and Social Justice, American Society of Criminology. Thank you so much, sir, for gracing us today with your benign presence. I will now like to actually hand over the session to Professor G.S. Bajpai, who will be assisted by Mohit Salvi for the question and answer round forward. We will be waiting thereafter for Dr. George Richards, who will be joining in a few minutes. Thanks, sir. Over to you, Professor G.S. Bajpai.
Very good evening to all from my side, and I take this opportunity to first of all thanks the organizers of this tremendous event, Dr. Shrikar and Anika, and I can also see that Michael and Mr. Emilio, they're all there, so welcome all. And I take this opportunity to welcome the key speaker for the session, Greg Barak, who is going to speak on supranational criminology, the case of Ron Kramer's urban criminals and climate crimes. This looks very exciting for all of us, for various reasons, because these are the international issues which cut across the boundaries of all the nations and uniformly experienced by all of us in some way or the other. Uh, this particular event and this session is significant for two reasons. One, Dr. Shrikar has brought supranational criminology to the discussion, and in itself, it is a great development and beginning, in the sense that it would be a great experience to see how the traditional and conservative criminology tries to expand to address the issues of international concern. And in that process, I do believe that the theoretical underpinnings or theoretical frameworks that the traditional criminology has will also be going to change. And I have yet to see how the theoretical boundaries of supranational criminology would evolve, especially when it tries to address the issues like war crime, genocide, or environmental criminology or green criminology. In many nations, I would say internationally, there is a need to theoretically, establish the boundaries of supranational criminology. And to that extent, this particular interaction is going to be very, very useful, because this is one model of criminology which concerns all globally. So therefore, the theoretical understanding and the practical applications of the debates that we are holding on several issues within the framework of supranational criminology are going to be very, very relevant. So I reserve my remarks for the end, and this is the time to invite Professor Greg Warak, and we'll listen him. And Dr. Shrikar, I think we have around 30 minutes for the speaker. How much time you are going to give for the speaker?
30 minutes. 30 minutes for his talk and around 15 minutes for the question and answer.
So I think 30 minutes is a pretty good time for all of us to listen Mr. Greg, and probably then we can have some question and some remarks, and we'll try to learn more on the topic, a very exciting topic that he has chosen for this evening. So welcome, Professor Greg, and over to you. Can you unmute your mic, please? Can you unmute your mic, please? Yes, that is all right.
Yeah, you okay? Good evening.
Yes, sir. You're audible, sir. You're audible.
I am lecturing to you from Ann Arbor, Michigan, in the United States during a period of interrelated worldwide disturbances. The most obvious are the COVID-19 pandemic and related healthcare crises, the economic and debt crises, the ethnic and migratory crises, and the global warming and climate crises. While these are all worthy subjects for supranational criminology to investigate, I have chosen to focus on ecocide, or to the extensive damage to, destruction of, or loss of ecosystems by human activity. Presently, global warming and climate change have reached a point where peaceful coexistence of Earth's inhabitants is increasingly destabilizing. From a global perspective, the struggle for ecological justice and the failure to hold climate crimes and carbon criminals accountable is arguably the existential threat facing planet Earth. In recent decades, a solid body of international criminal law has been created, but it still does not include ecocide or some other variation of state corporate environmental violence. Although there has been no codification to criminalize environmental violence, destruction, some global advocates would like to include the crime of ecocide as the fifth international crime against the peace. joining the crimes against humanity, the crimes of aggression, war crimes, and genocide. Because the crimes of global ecocide are ominous and preventable, these crimes against Earth's ecosystem should be the concern of all criminologists. Before talking about the field of supranational criminology and then pivoting to climate crimes and carbon criminals, allow me to briefly frame the environmental problem of climate change and global warming and its relation to crime and crime control. Since the mid-20th century, scientists have attributed global warming to the expansion of the greenhouse effect, or when the atmosphere traps heat radiating from the Earth toward space. In other words, there are specific gases that work in combination to block heat from escaping Earth, so the planet is warming up. The most relevant natural gases are water vapor, nitrous oxide, carbon dioxide, and methane. There are also chlorofluorocarbons, or synthetic compounds of industrial origin that are currently subject to international regulation because of their ability to destroy the ozone layer, which helps to shield Earth from harmful ultraviolet rays. Some basic facts about these gases are: the most abundant greenhouse gas is water vapor that acts as a feedback mechanism to stabilize the climate. Water vapors, as well as the possibility of clouds and precipitation, increase as the Earth's atmosphere warms. Carbon dioxide, though a minor component of the atmosphere, is important because it is released through natural processes such as respiration or volcanic eruptions, and by certain human activities, including deforestation, land usage changes, and the burning of fossil fuels. Since the Industrial Revolution began, humans have increased the concentration of atmospheric carbon dioxide by more than 1/3. Methane, a hydrocarbon gas, is also produced through natural sources and human activities, including the decomposition of waste in agriculture and in landfills, as well as through animal digestion and manure management associated with domestic livestock. Methane is much less abundant than carbon dioxide in the atmosphere. However, on a molecule-to-molecule basis, methane is a far more active greenhouse gas than carbon dioxide. Nitrous oxide is a powerful gas produced by fossil fuel combustion, nitric acid production, biomass burning, and soil cultivation practices, especially those using commercial and organic fertilizers. To make a very long story short, the atmospheric carbon dioxide levels in the last 150 years have risen from 280 parts per million to 411 parts in 2020, higher than at any point in more than 800,000 years. Similarly, global emissions on planet Earth are now at an all-time high. That is to say, the most important metric of climate health, the amount of carbon emissions, suddenly just got worse, making the largest year-over-year increase in the United States, the end of the Great Recession. Unfortunately, this increase matches the emissions trends around the globe. According to two major studies cited in the Atlantic magazine dated January 2019, greenhouse gas emissions shot up worldwide in 2018, accelerating like a speeding freight train, as one scientist put it. The statistics from 2018 were all the more dismal because greenhouse gas emissions had seemed to be slowing or even declining both in the United States and worldwide. Most significantly, the global scientific community has asserted with more than a 95% probability that human activities over the past 50 years have been responsible for the increasing concentrations of atmospheric carbon dioxide. In other words, the ramping up of the greenhouse effect has been shaped primarily by human productivity, especially the burning of fossil fuels like coal or oil, and by the human consumption of commodities and technology. As a consequence, the Earth is getting warmer, leading to more water evaporation and precipitation overall. In turn, some geographical regions in the world are becoming drier and other regions are becoming wetter, which destabilizes the makeup of natural plant communities, influencing where crops can be grown and altering migratory patterns of birds, fish, animals, and humans. In the meanwhile, glaciers as well as other ice formations are melting, sea levels are rising, and the oceans are becoming warmer. According to recent climate change research, the epic migration set to disrupt the world has already begun because of rising sea levels and because of hotspots emanating from the sub-Saharan Africa to South Asia to Latin America. Climate change models have projected that by 2050, more than 150 million people globally will have been displaced from their homes due to rising sea levels alone. Over the next 30 years, for example, models of Central American hotspots have projected that as many as 30 million migrants will head north toward the United States to escape from drought, food insecurity, and organized street crime. However, if governments take only modest action to reduce climate emissions, the number of migrants moving to the United States could shrink to less than 1 million between now and 2050. Models have also indicated that without reducing carbon emissions by 2030, the number of people living in city slums worldwide will be around 2 billion people, or 2/5 of the Earth's population. As for the implications of these trends for crime and crime control, strain theorist and a past president of the American Society of Criminology, Robert Agnew, made criminological news back in 2012 when he discussed likely reactions to the projected worldwide food and water shortages. Agnew wrote in his article, Climate Change and Crime in the 21st Century, a Dire Forecast, published by Theoretical Criminology, that, quote, climate change may move us toward a Hobbesian state of nature, with individuals and groups struggling to survive in an increasingly brutal and unregulated environment. Agnew asserted further, there is good reason to believe that climate change may become the major driver of crime if efforts to dramatically reduce carbon emissions continue to falter. End quote. I ask, could Agnew's forecast also be true of urban areas in the global north where rising temperatures and shorter winters, as well as increases in emissions from fossil fuels, have, for example, contributed recently to the National Climate Assessment's reclassification of New York City from a humid continental climate to a subtropical climate? Historically, most crimes and human rights abuses by the powerful, whether perpetrated at the organizational, institutional, or structural level, have always been exceedingly difficult to corral in legally. As a consequence, these crimes often remain far beyond incrimination. At the same time, these state corporate actions and or omissions are never indivisible from the contradictions of non-sustainable capital accumulation and reproduction. Similarly, even when these environmental harms are the subjects of criminal or civil law, not unlike the crimes of multinational corporations, their violations are under-enforced at best and ignored at worst. Hence, green criminology treats these harmful acts as crimes, whether or not they are considered formal breaches of the law. In effect, this expansion of the legal definition of crime has allowed for those acts that are just as harmful or more so than any of those acts that have been previously defined and enforced under the law to become, by way of analogy, morally blameworthy, the same as other violations of the criminal or civil laws. In 2015, green criminologists Lynch, Long, Stratetsky published their comprehensive empirical findings on the relationship between the development of capitalism and the decline of animal species. Specifically, they examined the viability of non-human animal populations as a function of systemic ecological harm. By systemic, they were referring to, quote, those ecological harms that are endemic to capitalism as a system of production and which in the current context of global capitalism are also global in their appearance and therefore are structural in origin, end quote. Their two research questions were, to what extent does capitalist development produce ecological disorganization? And to what structural degree is capitalism criminogenic toward the environment? The environmental issues that Lynch et al. Were investigating included the endangerment and extinction of species, as well as the relationship of species viability to the forms of ecological disorganization that are produced by capitalism in its ordinary course of development. Among other conclusions, they found that the capitalist treadmill of production drives economic development to continually expand in the pursuit of profits, regardless of the consequences to the ecosystem. Finally, with respect to environmental change and its destruction, they argue that nature has been caught up in the treadmill of production in two important ways. First, by way of the extractions from the earth of raw materials and energy resources necessary for production, and second, by way of the pollution caused by these extraction processes of production. Let's now briefly discuss the recently developed field of supranational criminology. Back in 2008, as part of its book series, Supranational Criminal Law, Intersentia published Supranational Criminology, Towards a Criminology of International Crimes, the first book-length volume on the subject, edited by Alette Schmullers and Roloff Havman. For the 600-page volume, I wrote one of the chapters for part one, Define and Conceptualize International Crimes and State Crime. I entitled that chapter, Towards an Integrative Study of International Crimes and State-Corporate Criminality, subtitled A Reciprocal Approach to Gross Human Rights Violations. I began, As we inaugurate a supranational criminology that we hope will become a new criminology that develops and expands its influence over time in the world of gross human rights violations, we should seek to become not only a multidisciplinary and comparative field of investigation, but we should also give careful examination to the historical record. I continued, a supranational criminology should be both backward looking and forward looking, so as to be able to best shape our political praxis in between the past and the future. I upheld that supranational criminology should be about the intellectual enterprise of linking or integrating what has been with what could be done, especially in light of the historical reality that human rights violations and related crimes have always been elusive when it comes to their legalized repression. I still advocate that this type of epistemological and methodological approach is essential, not only for the purpose of establishing justice and closure for the victims of these types of crimes, but also as a means of helping one to establish standards for measuring the gravity of ordinary and extraordinary crimes against humanity, and two, to change locally and globally the interconnected remedies of justice, accountability, recovery, and restoration. I finished the chapter by saying that the type of integrative and reciprocal praxis that I've been sharing, as well as my desire for a developing supranational criminology of international and state corporate crime, relied fundamentally on the understanding that the normalization or not of the violation of basic human rights is ultimately about global inequality and social oppression. I also maintained that in a world of differential power, geopolitical conflict, and global capitalism, we criminologists need to align ourselves, on the one hand, within the reciprocal relations of the intersections of government and business, and on the other hand, within the social movements for economic sustainability and global reconstruction. This type of criminological application allows us to expand that which we label and potentially codify, from ordinary crimes to gross human rights violation. In this way, supranational criminologists can facilitate or contribute to the global release of the necessary social political forces to bring about just international governing relations rather than international governing bodies for controlling these harmful behaviors within and without the penal law. In the rest of this presentation, I rely on the synthesized ideas, integrated arguments, and policy implications from Ronald C. Kramer in his recently published book to demonstrate the value of mixing the tools of green criminology and supranational criminology with economics, history, and environmental science. In his introduction to Carbon Criminals, Climate Crimes, published a few months ago, Kramer tells us that he decided to write this book after completing a summer reading project on global warming and climate change. Kramer says that his reading revealed two things to him. First, that climate change is a threat to our very survival. Second, that the literature on global warming and climate change is chock full of crime language, and to a somewhat lesser amount of criminal language. One interesting example of expressive criminality came to public attention after the publication of Kramer's book. In an interview with Noam Chomsky, published in the Jacobian magazine on June 23, 2020, the famous Lindquist stated that President Trump's rollback of environmental protection laws in the US and other actions to accelerate global warming and climate change, including his pulling the United States out of the Paris Climate Accord, made him, quote unquote, the worst criminal in history. In a similar vein, I would add that Trump's anti-scientific approach to COVID-19 and his criminally reckless response to the pandemic should not only make him and his administration liable for the needless deaths of more than 100,000 Americans already, but also for plunging the US economy into what is becoming the Trumpian depression of the 21st century. Both environmentalists and green criminologists have not only been referring to global warming and climate change as ecocide, but they have also been labeling these actions or inactions as crimes against humanity, as intergenerational crimes, as international crimes. As for the perpetrators of climate crimes, criminologists can easily identify the CEOs and the corporations, as well as the politicos and those nation states primarily responsible for global warming and climate change. As for the heads of these organizations, criminologists can add their names to the history's list of the greatest elite criminals of all time. For example, South African activist Kumi Naidoo, as the former executive director of Greenpeace International and the Secretary General of Amnesty International, famously exclaimed after the 2009 Copenhagen Climate Conference, quote, "The city of Copenhagen is a climate crime scene tonight, with the guilty men and women fleeing to the airport in shame. World leaders had a once-in-a-generation chance to change the world for good, to avert the catastrophic climate change. In the end, they produced a poor deal full of loopholes big enough to fly Air Force One through," end quote. As these examples reveal, the concept of crime is being used as a symbolic device or as an expressive term to convey a deep concern over actions regarded as both moral transgressions and blameworthy harms. Materially, however, there are no guarantees that crimes like these will become adjudicated breaches of morality formally defined by the law. Often, serious crimes like these do not have readily identifiable victims, nor the necessary moral support from the population at large to reach a legal tipping point of criminalization. As we are reviewing here, gross harms against person and property are occurring 24/7 due to global warming and climate change. That is to say, millions of humans, animals, and plants worldwide are already experiencing both physical harm and emotional trauma. Indeed, as I have noted, these social realities have already evoked more from tens of millions of environmental onlookers worldwide. Unfortunately, the global outrage has not been enough to overcome these harms and wrongdoing perpetrated by some of the world's most powerful corporations and economic managers. In short, these organized wrongdoers have preemptively justified and prevented their harms from becoming codified into law in the first place. As with other corporate and state harms that have been denied and left unsanctioned by the law, there are additional political actors and lobbyists that have collaborated with these powerful perpetrators to neutralize their widespread victimization. Of course, the question remains, will global movements for environmental and social justice will global movements for environmental and social justice become strong enough in less than 15 years to overcome the economic interest of carbon criminals and the climate crimes before global warming surpasses 1.5 to 2.0 degrees Celsius above pre-industrialized levels? My dog is barking. That's why I'm losing my concentration. Sorry. 1.5 to 2 degrees Celsius above pre-industrial levels, and the Earth experiences irreversible ice sheet loss and sea level rise increases. Again, even if these environmental crimes manage to be proscribed in the law, the consequences of their harms and injuries will likely remain difficult to prosecute locally or internationally. After all, this has been the track record for most other incidences of gross human rights violations. Kramer characterizes his book as an exercise in green criminology and in the application of the concept and theory of state corporate crime. Distinguishing his work from the older environmental criminology, Kramer aligns himself with the green criminology and its perspective for expanding the older environmental approaches to crime and victimization research. For example, Kramer focuses his analysis on the relations between crime or criminality and environmental laws, as well as on the evolving meaning of environmental crime and the struggle for ecological justice. Specifically, green crimes involve those harmful activities defined legally or illegally, which not only cause injury to individuals and the environment, but also threaten the well-being of wildlife, impact business supply chains, and pose dangers to the welfare, security, and stability of the Earth's ecosystems. Some 3 decades old, the idea of state corporate crimes first emerged out of the work of Raymond Michalowski, Kramer, and several of their colleagues as they came to the realization that many forms of organizational crimes were often the products of business corporations and state agencies engaged in enterprises of mutual interest. Today, the concept of state corporate crime generally refers to these serious social harms that result from the intersection of powerful political and economic groups or organizations. Kramer specifically identifies 4 climate crimes or morally blameworthy harms related to global warming and climate change. These include 1, crimes of continued extraction of fossil fuels and the emissions of greenhouse gases. He argues that these criminals include, for example, the 90 carbon majors or organizational corporations and state actors responsible for 70% of the world's emissions. These criminals also include President Trump and his administration's actions to resurrect the Keystone XL pipeline to promote coal and to continually drill for oil offshore and on federally public lands. Second, crimes of political omission, or the failure to reduce emissions of greenhouse gases. These negligent crimes refer both to the political failures of the international political community and to the Trump administration's lack of a plan for mitigating emissions. Other crimes of omission by Trump include his withdrawal from the Paris Climate Agreement and his plans for killing clean power, for which Trump et al. Are the defendants in the Children's versus Trust lawsuit, Giuliani versus the United States, filed in 2015 by 21 youthful plaintiffs and still undergoing interlocutory appeals in the courts. The third crime, crimes of socially organized denial. I like this one. Crimes of socially organized denial. These crimes include the political and ideological denial of climate change and the rejection of climate science. These crimes/criminals include the actions of the fossil fuel industrial corporations such as ExxonMobil and Koch Industries, conservative foundations/right-wing think tanks such as the Cato Institute, the Heritage Foundation, as well as the Heartland Institute, and many Republican Party politicians, as well as Trump's appointees, all climate deniers to his cabinet. These politicals, like Scott Pruitt, who spent a life in law fighting environmental protection, heads up the Environmental Protection Agency. And like his cohorts, all treat the science of climate change as a hoax that benefits other nation states such as China. His fourth crime, climate crimes of empire, such as blood for oil, or the politics of the armed lifeboat, Pentagon emissions, and the militaristic adaptation to climate disruptions, including military buildups, deportations, the locking up of young children in cages and separating them from their undocumented parents, and the building of border walls. Lastly, these crimes of unjust and militaristic adaptations also exclude or push back against any progressive, ecologically just policies from entering into the political arena, such as its rejection of the Green New Climate Deal. After spending much time making his case for carbon criminals and climate crimes, Kramer reconnects his opening historical narrative on global warming, climate change, and green criminology with the forward-looking movements for environmental justice. Striving to make these crimes and criminals more than merely symbolic and expressive epithets of moral disgust, Kramer explains how criminologists can connect with the social movements for environmental justice and what we can do to be part of this struggle. For openers, criminologists need to do our homework, to educate one another and to educate our students about the dangers of global warming and climate change and about the preventable remedies to reduce ecocide. More specifically, criminologists need to reinforce in multiple ways and arenas, such as this webinar, the public condemnation of carbon criminals and climate crimes. Criminologists also need to lend our support and, if possible, get involved with international movements and environmental organizations to put an end to the age of fossil fuels and to help build a just world of community-based, renewable, and clean energy for all. Some of these environmental movements include, but are not limited to, the 350.org, the Sunrise Movement, Blockadia, Extinction Rebellion, and the Fossil Fuel Divestment Campaign. Examples of environmental legal groups include such nonprofits as Earth Justice, the Center for International Environmental Law, and the Environmental Defense Fund. Collectively, groups like these and others are trying to come together to develop an integrated and expanded progressive movement with broad goals for developing newer and stronger international agreements that go beyond the Paris Agreement. The overall joint objective of these groups and organizations is about investing locally and globally in the transition from fossil fuels to solar and wind energy, rebuilding the public commons, and achieving climate justice. Ideologically, what holds these organizations and their shared global visions together is the desire to reinvigorate the historic public trust doctrine as a guiding legal principle on matters concerning the environment. The public trust document still operates in many legal systems today whose roots were derived from ancient Roman law. The public trust doctrine has been used in countries around the world to protect water bodies, shorelines, fresh water, wildlife, and other natural resources. Over time, however, the public trust doctrine, or nature's trust, as it is also called, has been contracting in the hands of those governments that have taken a statutory or regulatory approach to the environment. Significantly, this approach has allowed for the decimation of natural capital by the interests of privatization. Accordingly, environmental activists have been pushing back against privatization and forcefully arguing for expanding the reach of the doctrine to cover all of the critical natural capital and ecosystem services that support the well-being of humanity, biodiversity, the atmosphere, and the oceans. Lastly, with respect to the existential threat of climate change, I leave you with the reflections of Robert J. Lifton from his 2017 book, The Climate Swerve. Lifton maintains that psychologically, the human species is capable of swerving or doing away with harmful habits. After all, we have the power not only to become aware, but also to change our ways, to alter our course of self-destruction, and thereby avoid the impending climate change disaster. Ultimately, when what humans have made, we can unmake and remake if we don't wait too much longer, because the climate clock is ticking and time is running out. Thank you. Thank you.
Thank you, great, for such a brilliant presentation. In fact, we were all, thinking with rapt attention the journey of ideas that you have taken, and your bottom line that the clock is ticking and we have to be a lot more careful on this. Couple of remarks, and then probably we can open the session for some questions, or as the organizers may like it to be. This particular presentation contains three very major aspects which we have noted with utmost care. Uh, the focus of the discussion was on the consequences of global warming and the climate change. The great part of this entire exposition was that you have very, ably linked the entire presentation with two very important aspects. You have viewed the consequence of global warming and climate change with human rights violations, and you have brought in the required liability principles that should serve as a check on the states or on the organizations, on the corporates, and so many other partners who are responsible for maintaining the environment or who are liable to maintain these things. The international criminal law does take some of these things into consideration of the Paris principles and public trust doctrine, as you have mentioned. But important part which I have noticed in your presentation was that you have alerted us with some very crucial implications of this particular development when you say that 95% of displacement and migration is likely to be resulted from some of these effects. And you have also mentioned, which I noticed with a lot of interest, and it could be a very important takeaway from this presentation, and for it can motivate further research. When you say that climate change can be a major driver for criminality, major driver for criminality, and you are talking about so many negative consequences of global warming and climate changes, and the the human rights violation issues that you have presented as a consequence of these developments, and thereby you have emphasized the global oppression, equality, global conflict, regional conflict, role of the states, powerful corporations, their CEOs, their liability. So I think for a criminologist, there can be a lot to look at. And I feel that this entire debate you have located in your second part, where you have started contextualizing some of these issues within the framework of supranational criminology. You have very nicely fixed the entire thing in the framework of supranational criminology. When you say some of these things do fall within the framework of supranational criminology, as these are the crime against humanity, and you are talking about fixing the liability. And to me also, the basic principle you have mentioned very passingly, of course, about the criminalization, because in the environmental laws or environmental criminology there are so many omissions, political omissions you have mentioned. I would say even there are other kinds of administrative and regulatory omissions as well. Regulatory omissions are largely responsible of a great degree of environmental hazards, and therefore I consider them to be fitting into the framework of criminal law because they are wrongful, they are harmful, and they are, as long as they are harmful and wrongful, they they satisfy the test of criminalization, because some of these things still continue to be regulatory in nature. In many countries, for instance, environmental violations do not attract penal or criminal sanctions, because primarily we treat them as civil liabilities issues. But making them criminal liabilities issue, some of these things can be very, very challenging. And this can become a very interesting question, whether it is the high time to consider some of these omissions are regulatory omissions, regulatory violations within the framework of criminal law. In India, especially, I will tell you, uh, lately some of these things have been brought within the purview of various criminal laws which attract punishment, not fine alone, but imprisonment or other criminal or penal sanctions. So it can be a challenging task before the criminologist in so many countries. What are the environmental hazards resulting from climate change, global warming, or so many omissions which can be brought into the purview of the criminal sanctions, because these can be very, very severe. And for me, as a criminologist or a victimologist, you have mentioned the emotional trauma and physical harm as a consequence of some of these developments. So, environmental victimization is something which is very, very important from the viewpoint of environmental victimology, because people are suffering because of the acts and omissions of others. So, to my mind, some of these things are very, very important, and your expression, the phrase that you have used, socially organized denial. Socially organized denial is very, very important, because probably the awareness to the environmental issue, collective, or I would say collective awareness, is not much. Therefore, if you see the debates in green criminology, they are picking up some of these ideas to formulate the theoretical boundaries of some of these debates, especially the Michael Lynch in 2014 towards green criminology. He is talking some of these things, uh, including the criminal behavior, or including the resultant consequence, environmental crime, regulation, liabilities issues, and Agnes Nurse also in her book on environmental green criminology have mentioned some of these things. Uh, Within the framework of supranational criminology, I feel that since this field is evolving, and there is an interaction of a couple of parallel disciplines like pure environmental science, environmental law, and environmental criminology. There are overlapping intersections in some of these disciplines. So, therefore, it is very important for the criminologist to identify the conceptual boundaries of the issues which could be addressed within the framework of green criminology or environmental criminology, and which have implications to the global world, because environment is a global issue. And as long as it remains the global issues, it definitely forms a very important debate in the supranational criminology. I feel that laws are required to be fine tuned more and more to take into account the chronological aspects, because from legal aspects I understand the environmental law has grown to be a very, very important body of knowledge and practice, but environmental criminology has not grown that much in so many countries. For instance, in India, we couldn't conceptualize environmental criminology or green criminology to the extent that we start, deriving the ideas from the environmental violations and environmental omissions. It's a very, very thought-provoking lecture by Professor Craig, who has, opened up so many issues before us. I think it's a very, very comprehensive presentation because it has touched upon some very crucial issues. I can understand that he was full of information on so many aspects, but he was trying to probably curtail certain areas for want of time and other things. But I think uh, he has provided us tremendous insights today. Thank you for this wonderful exposition of environmental green criminology within the framework of supranational criminology. Thank you so much for speaking today to us. Thank you. Over to you, Srikant. Yes, over to you.
Yes, sir. So, if we have any questions from the participants or the audience out here in the Google Meet, we can start with that, and then
Yes.
we will take up questions from the YouTube.
So I invite the listeners who are present today here, if they have any doubts, doesn't matter if it's a very preliminary one, he is an expert, of course. But even if you have a very primary, query or anything relating to supranational criminology as such, or anything that he has spoken about, you are most welcome to raise that in the chat box, or they can speak directly. Yes, please. Jayesh, you want to speak something?
No, sir.
Mr. Mangoli?
I'm waiting for a question, right? I'm still waiting for a question. Thank you for
Sir, good evening, sir. Good evening, sir. Just I would like to know about the wild animal traffic. Whether it is come under green crime, green criminology.
Okay.
So, Professor Greg Bork.
Yeah, great. Could you hear the question? He has asked the
about wild animal traffic.
Wild animal trafficking.
Okay, I mean,
yeah, it is coming under green criminology.
Right. I'm sure that it would. My immediate reaction, because I was not thinking about wildlife trafficking when I put this together. My immediate reaction upon hearing you raise the question is, yeah, it would be natural to incorporate, but correct me if I'm not mistaken, there are laws, national and international, against this already, are there not? I pose that as a question. I think it should fall under my general analysis, but I'm also responding back that I think there is law already on codes, national and international, that address this. There are others there that might correct me if I'm mistaken. Does that make sense? Am I making sense?
Yes, thank you. Thank you so much.
Yes.
Thank you so much.
Thank you, sir. Thank you.
Any other? Asmita, you want to
We will ask Mohit to read out the questions from the YouTube live session. Some of the audiences have asked some questions out there. A couple of questions are there, so we can just ask him to read out the questions. Mohit, please.
Please go
Thank
ahead.
you, sir.
Please go ahead.
Thank you so much for an informative session. So we have a question from Mr. Arivu that please suggest any book or study material on marine species trafficking prevention in concern of supranational criminology.
Am I aware of supranational criminology addressing international human trafficking? Is that the question?
Yeah, he is especially asking marine trafficking, marine species trafficking related book or any material on supranational criminology. Any work on marine species trafficking?
Peripherally, I am aware of some work on piracy and international marine trafficking. I could not pull those citations off the top of my hat, but I think if one Googled, one could find such publications. Not a large volume, but there's some literature there.
Thank you, thank you. Next, please.
Yeah. So next is from Miss Nabandita. That is the MNCs being a major stakeholder in uplifting the imbalance caused in the environment. How can this be resolved as sound economy is also a major ingredient of development?
If I understand the question, how does one balance moving away from dirty coal to clean energy? How does one balance that? Is that the question? How does one balance sustainable productivity against the older productivity that's not sustainable? Is that the question?
Sir, I will repeat the question. So the question is the MNCs being a major stakeholder in uplifting the imbalance caused in the environment. How can these be resolved as a sound economy is also a major ingredient of development?
May I simplify this question to you, Greg? May I simplify this question to you, Greg?
Please. I'm sorry.
So the question is, how the MNCs, multinational companies, should be held responsible for their acts relating to the environmental degradation, because at the same time they are also crucial for the economic development of the country. So how you can balance the development role played by the multinational and the environmental protection?
Okay, I guess I did understand the question, and my response is that that's precisely what we have been, in a half-assed way, trying to do for the last 30 or 40 or 50 years, and we have not balanced. We have not slowed down that process. And here's the question. If we continue to play this game, the game is over. It's not a question of how does one balance that. It's a question of how does one adapt? How does one realign? How does one reconstruct? How does one stop the dependency on coal and fossil fuels? Boom. It has to end. We have to move to other forms of energy. It's not a question of trying to balance the two. It's recreating a whole new system of working relations for people who were in those dirty industries to convert into the clean new industries. I hope that's...
I think last question, probably. Please have last question.
Okay.
So the next question is from Nabandita again. That is, how can the overexploitation of natural resources be controlled?
How can we extract and be controlled?
Yes.
Is that the question?
Yes.
Yeah. Basically, what we're trying to say is, in response to the question of, I'm not that excited about criminalizing these acts. I don't have a lot of faith in international law to regulate or heinous. So I'm not necessarily wanting to criminalize those perpetrators, although that's fine with me. I want to prohibit the production, period. I want to end that form of energy. And how would I do that? I just pass law to say you can't engage in this activity anymore, because if you do, we all die, or the next generation, or the next generation. The game is coming to an end. So how do you stop it? You get a consensus that says, hey, we're not on a mission to death here. We'd like to survive, or our generations after us would like to survive. So it becomes what is necessary. Collective will to outlaw this. You say you can't engage in it, period.
So, all right, I guess.
I have an observation.
Yes, please.
Yeah, since this environmental crime, environmental issues is a global issue and supranational, I think at the Indian scenario, we are not yet started the serious research in the green criminology as well as environmental criminology, it seems. So I want to know particularly about the Bajpai sir. Your suggestion, please, on to take up these serious studies, particularly research in these areas.
Are you asking me to evaluate the research in those areas, or to discuss what I've done in those areas?
Professor Craig, he has addressed this observation to me. I'll not really respond it, but I can make a counter observation.
Okay.
The issue is, as I have said, it is high time that let us have green criminology as a paper in our master level courses in criminology. In many places, it is an elective paper. In some cases, but I am for a more customized Indian version of green criminology, not the Western version of portrait, green criminology, because back home we have lot many issues, and which we see, like Greg was also mentioning, migration, displacement, climate change. They are forcing the people to indulge into several kinds of situation and behavior, which are very, very significant and crucially important from the viewpoint of criminology. And somehow those concerns have not been very seriously evaluated and researched in India. So empirical understanding of some of these issues is virtually absent. And it is high time, therefore, I think, that the green technology should form a very important focus in master's degree program in this country, and thereby you can probably promote some research in these directions, and a criminologist would matter, I would say, in such pursuit. Thank you. So, Srikar, it's over from my side, and I formally thank Greg for a brilliant presentation, and all the participants for raising some very interesting questions. Over to you.
Thank you for your comment, Derek.
I would like to thank Professor Greg Barrett for his very well articulated discourse on supranational criminology. And indeed, it was a very entertaining and a very thought-provoking session. I would now like to request Dr. Srikar Lama to say the word of thanks. Over to you, sir.
Good evening, all. First of all, I would like to thank Professor J.S. Vajpayee for agreeing to be the chairperson of this session and also giving his insightful outputs. Since it's a virtual platform, we are really sorry we are not able to gift any memento or anything in this particular virtual platform. So we'll just present a certificate of appreciation as a token of our gratitude, a small token of our gratitude to Professor J.S. Vajpayee. And we are really thankful to you, sir, for giving us your time and your valuable inputs. I would also like to thank Professor Greg Barak, who is one of the key theorists of supranational criminology, and he has given us his precious time. And he woke up at 6 o'clock and has attended all the sessions and given us a very insightful, a very informative lecture on particularly green criminology. And we would also like to present you a certificate of appreciation as a small token of our gratitude towards you. And we are also thankful to all the other participants out here, Professor Mangoli, other academicians where I can see Dr. Amruta, Dr. Mahendra Simakarna, and others. And I would also like to thank all the participants from all around the world. And last but not the least, I would like to thank my research scholar Jayesh and my students Samir, Shashank, Anika, and Mohit for helping me and contributing in the session. And I will also thank Professor Jacko is also here, who has given his time and listened carefully to the session. Thank you all. Thank you so much.
Thank you, Shika. I'm logging out. Thank you,
Thank you
everyone.
so much, sir. Thank you.